Everybody good? Good afternoon. Welcome to Banking and Consumer Affairs Subcommittee. We'll jump right in here. I know we got a long calendar. Any personal orders before we get started? Madam Clerk, will you please open up the roll call? Madam Clerk? Well,
Mr. Chairman,
please take the roll.
you have 5 members present. You have a quorum.
Thank you, ma'am. Like I said, we're got a lot of bills on hand today, and the legislature might get slowed up by 99 reasons, but banking's not going to be one of them. So we're going to roll right through there. We're ready for House Bill 2502. Motion by the Speaker. Second. Hey, are you running the Speaker's bill? Okay, yes, sir. We got a motion and a second? Yep. We're in proper, well, there is an amendment with this, right?
That's correct.
And what's your drafting code?
Chairman, I might need a little assistance with
Yes,
my
sir, I can
drafting
give it
code.
to you. I hope it resembles 15378.
As a matter of fact, it does.
All in favor of adding the amendment, say aye. All opposed, nay. Sir, we're in proper motion. It's all yours.
Thank you, Mr. Chairman and committee. This legislation on behalf is coming through Speaker Sexton. Have the privilege to be here on running the bill for him as well as the other folks. This initiates in Tennessee and transmitted to a foreign country. This is initiates a wire transfer fee. Currently, over 16 million transfers totaling $5.5 billion are initiated in Tennessee and transmitted to a foreign country, according to the Department of Financial Institution. This bill allows for taxpayers to apply for a refund for the $5.5 billion leaving the state untaxed each year to foreign countries. And the bill would create a fee for funds leaving Tennessee to a foreign country. This fee would be $10 per transaction, 2% of funds over $500. And this refund to taxpayers through this fee would result in over $155 million per year in recurring revenue and local revenue across the state. And that pending any questions, Mr. Chairman, I seek passage.
Thank you, Chairman. Any discussion on the bill? Representative Hemmer.
Thank you, Mr. Chair. Appreciate the sponsor bringing this bill. I was just kind of looking over the fiscal note. It's a pretty hefty amount, and I was just kind of curious. It just seems odd. We're putting $160 million. It's looking to raise tax on corporations, on individuals that are sending this money, and it's not just individuals. It truly is the company. It's from looking at Department of Economic and Community Development data for our foreign direct investment. We've got about $50 billion of foreign direct investment, 160,000 jobs here in Tennessee related to this. I was just kind of curious. Wouldn't this bring a chilling effect on this foreign direct investment and related economic development activities for these companies who are trying to recruit here?
Chairman.
Thank you, Mr. Chairman. I don't think so. I think we're really talking about two separate things. These are funds that would be coming from a fee from money that is being sent outside of the state. And I think what you're referring to would be a direct investment by outside entities, maybe by outside the state or outside the country, corporations or folks that want to invest. And of course, we welcome that in Tennessee, but I don't think that the two are necessarily intertwined.
Representative Hammer.
So would it be correct if this bill were to become law that a company that, for example, say Nissan, that is here and they're having to put forth money back to Japan from the money they've earned here, they would be subject to that tax?
Chairman.
That's something that I'll have to get back to you on. I think the intent of the legislation is really intended about the individuals and that are sending money outside of the state from a wire, not necessarily the larger business transactions. But I want to clarify that. But I'll need to do that if we're fortunate to get out of sub and to get into full, and I'll make sure to get you an answer on that.
Yeah, I'll just thank you for that, Mr. Sponsor. And I think that's, from my time being in economic development and recruiting these companies, going overseas, and knowing how, many of them are coming to Tennessee and trying to be good citizens and employing us and providing that foreign direct investment. And now we're taxing them for the pleasure of doing business here on top of the other taxes that we already charge, the F&E and others. It just seems a little too much. It seems too much for me at this point. Thank you.
Speaker Marsh.
Thank you, Mr. Chairman. And Representative, if I'm in a business here in Tennessee and I buy something in, say, Mexico, and I send them money from my bank, am I having to pay a tax or a fee on that money going into a foreign country?
Chairman.
The way that this legislation works, if a wire transfer is made in that scenario that you had suggested, yes, there'd be that fee would be paid. But again, as I understand it, the primary purpose of it is really intended for those folks that are sending money outside of Tennessee. And really it's geared toward the personal transactions of individuals sending money to other countries, not necessarily a business transaction, but that's not the primary purpose of the legislation.
Speaker Marsh.
Okay, so if it's not the primary purpose, but we're probably going to be caught in that, could we maybe make it clear that it's not for businesses maybe? Or I just think this could be considered another tax on business.
Yeah.
Of doing business in another country. I think we ought to make that clearer if you can.
Chairman.
Thank you, Chairman. Thank you, Speaker. I'm more than happy to, again, if we're fortunate to get out of sub, more than happy to work on that as we get from sub to full to make sure that that's clear.
Chairman Vaughn.
Thank you, Mr. Chairman. And to the bill presenter, I understand you're the co-sponsor as opposed to the origin of this bill, but I'm curious, is there a carve out? Let's say that for international companies that are headquartered in Tennessee, FedEx comes to mind. And would it apply to them moving money within their own company from, say they had to pay a fuel bill in Germany, but it originates on a wire transfer in Memphis? Is that going to be subject to this tax as amended? Because I know this amendment was pretty comprehensive.
Mm-hmm.
Chairman.
Chairman, that's a great question. And again, I think we're working on, and I think the Speaker's office is working on trying to clarify that and trying to get that part of it worked out. Because I think, again, the primary purpose is not to inhibit business, but it is really trying to affect and go after those folks that are spending and sending their money outside the state in those wire transfers. But the larger business transactions, I think that's something that we're trying to get worked out. But it is not completed yet.
Any more questions for the chairman?
One thing I'd add.
Chairman Vaughn.
Well, in this case, I personally am going to tentatively vote yes for this bill based on the fact that I understand our speaker's pro-business mindset and that this thing it needs some work, but I have confidence in the fact that office can produce the work that it would take. But we will be if it's fortunate enough to move out of here, then I would be taking a very critical eye on it to make sure a number of these items that we've got in front of us have been addressed.
Thank you, Chairman Vaughn. Any more questions? Well, I think we're ready to vote. Madam Clerk, will you open up the vote? Everyone voted. Madam Clerk, please take the vote.
Mr. Chairman, you have 6 ayes and 1 no.
The ayes have it. House Bill 2502 will head on to Commerce.
Thank you, Chair. Thank you, committee.
And I need to retract my steps just a little bit. I tried to put the cart in front of the horse. A little bit of house cleaning. Off notice will be item number 7, House Bill 2016. Also off notice will be item number 18, House Bill 2225. Item number 21, House Bill 668, be off notice. Item number 25, House Bill 2623, off notice. Item number 27, House Bill 1859 is also off notice. And also item number 16, House Bill 1661 is off notice. Rolling 1 week is item number 8, House Bill 1468. Also rolling 1 week is item number 10, House Bill 1898. Now, we're ready for item number 2, House Bill 2541 by Chairman Howell. No amendments with this, Chairman?
I have 10039, is that correct? Makes the bill.
Give us just a second, Chairman. Oh, that's just. Chairman Howell, please discuss your bill.
Okay. This bill is from the Department of Labor, and it's strictly a clarifying bill. All it does is clarify existing language. I know you've heard that before, but this one truly does. It's a technical clarification of existing law brought by the Department of Labor. I'll tell you what it does not do first. It does not create new mandates. It does not expand coverage, or it does not change current policy of the state. It simply clarifies statutory language. For example, it clarifies the definition of state contract to clearly mean that it's a written contract, not an oral contract. They have to be written. And it also clarifies where prevailing wage policy applies. Prevailing wage already applies to projects, construction projects that are federal and state funded. This clarifies that prevailing wage would also apply to those public highway construction projects, city or county projects that are also partially or fully funded by state and federal dollars. The last thing it does is it adds language allowing the Commissioner of Labor and Workforce Development or their designee to carry out the responsibilities under this statute. That's the 3 things this bill does.
Thank you, Mr. Chairman. Any discussion on the bill? Chairman Hale.
Thank you, Chairman. Move previous question.
That's a proper motion. I think we're ready to vote. Madam Clerk, please open up the vote. All those in favor, vote aye. Any opposed, vote no. Madam Clerk, please tell us the vote.
Mr. Chairman, you have 6 ayes and 0 noes.
House Bill 2541 will go on to Commerce.
Thank you very much.
We are ready for number 3 here. By Chairman Powers, House Bill 2529. Chairman, please tell us about your bill.
Thank you, Mr. Chairman. Good to be back in front of my prior committee that I used to chair before y'all kicked me off. And this bill has an administration bill, and it has clarifying language. No, what it does, it amends the Securities Act of 1980 by expanding investment advisor exemptions to include those exempted by the Commissioner adopted rules. It clarifies that the Commissioner may share confidential examination materials with other state regulators. It mandates that courts appoint the Commissioner as receiver or conservator for defendants of their assets and enforcement actions upon request. It imposes a statute of limitations on private rights of action earlier 5 years from violation or 2 years from discovery. It authorizes current or former Tennessee-based broker-dealers and agents to pursue expungement of customer dispute information, and it repeals the outdated provisions for educational cooperative scholarship plans. And with that, Mr. Chairman, I renew my motion.
Thank you, Chairman. Any discussion on the bill? Well, I think we're ready to vote. Madam Clerk, please open up the vote. All those in favor of House Bill 2529 moving on to commerce, vote aye. Any opposed, vote no. Madam Clerk, please take the vote.
Mr. Chairman, you have 7 ayes and 0 noes.
House Bill 2529 will be moving on to commerce.
Thank you, Mr. Chairman. Committee.
Ready to hear item number 4, House Bill 2611 by Chairman Halsey. Chairman, please tell us about your bill.
Thank you, Chairman, and thank you, committee. I appreciate your time. I know you have some folks here to speak on this bill. The long and short of this, you heard it last year, and I'm not going to, this is my last time presenting it to you. So I don't know if that'll milk any favor out of you or not, but I'm going to milk everything I can to try and help it. So the tenets of the bill is this, that people think that they own their own property when it comes to stock, and I don't believe they do. You go to a broker and you buy your stock, and when you get through, it has your name on it until he pushes a button and sends it to the great pool in the sky, which is the depository pool in New York. And it gets deposited there, doesn't even have your name on it now. And then it's used as collateral for loans. And all that's fine until you have a meltdown. And when you have a meltdown, then you have an insolvency of an intermediary. And when that happens, your stock that has been used as collateral for loans is not yours anymore. And priority is given to the controller of that stock, which ends up in a loss for you. Now, we've heard before what the experts say, and we're told to trust the experts. And who is that? Well, that's the Uniform Law Commission. They're the ones that built all this. And so what kind of experts are they? Well, their assertions have been false. Let's go through them. You've been told by them that you have priority, except you do not with insolvency of an intermediary. You're told that you have property rights, but you have no right to recover your property in the event of insolvency of an intermediary. This means it's not your property. You're told that no customer lost anything in Lehman. Well, except for the clients in Lehman that lost their stock. Some of them didn't get it back for 14 years. And the only reason they got it back then is because the federal government bailed them out. But now you have a federal government that's about $38 trillion in debt and can't bail out anybody. So if you have a huge meltdown, we all will lose everything. You're told that an agreement is required, except it's not. You're told that only property for which the customer has given consent is used, except all securities may be used as collateral by others. You and I are told that only property extended through the margin lending is used. No, all securities are used. You're told that margin accounts should be prevented. No, they're maintained by contract, which has always been the case. You got every right to borrow money against your stock anytime you want to, but that's contractual. This bill doesn't have anything to do with that. You and I are told that wrongdoing is prevented under federal and state regulation. Only it's not demonstrated by Lehman Brothers. You are protected by SIPC insurance. No, institutions are never protected, and no one is protected in systemic failure. And that's what I'm scared about. Either orchestrated or otherwise, if you have a huge collapse, we all will lose. Financial institutions in the state are protected by the present system. No, they have the liability, but they don't have the property. It's about securing for clearing. No, clearing operated for 26 years before this all started. Then they tell us it's all about electronic trading. No, electronic trading or NASDAQ operated for 23 years before Article 8 changes ever happened. How do we know all this? Well, this morning, I copied off my computer, looked up Tennessee code annotated for the UCC code, section 511, article 8, Uniform Commercial Code. And this is what it says. And this is what I want to change. Section B, under Article 8, Section 511. Additionally, if a creditor has control over the financial asset, their claim has priority over the entitlement holder's claims. Now, you're not called a stockholder anymore, you're called an entitlement holder. That happened in 94. If a clearing corporation lacks sufficient financial assets to satisfy both its obligations to entitlement holders and its obligation to a creditor, the creditor's claim has priority over the entitlement holder's claim. Which means that who controls your stock based on these 2 points has priority over your property. So you understand, if you have a small financial collapse in the middle of all this, you're okay. But you have a big collapse, and we will all be in subjugation because we'll all lose everything. The second part of this bill says you don't got to go to New York to sue unless you're under contract to do it. You can sue from the state of Tennessee. The reason that is a good thing is because it helps us. And Lillard in the Treasury, Lillard's sitting on $96 billion of TCRS funds over there. Part of that's mine. I paid in that my whole life so I can retire. I don't want to lose it. In a systemic collapse, I will lose it. Here's the kicker. The citizens of the state of Tennessee, even if you have a collapse and we lost all $96 billion, the citizens of Tennessee are still on the hook for that $96 billion because it's contractual. I don't know how they're going to pay it back. But this would help our treasurer because he would have the right under that kind of a failure to sue and sue from Tennessee. And it gives leverage that we wouldn't ordinarily have. I know you have some folks to speak on this bill. This is just 2 things. It changes who gets priority over your property. And it adds the ability to sue from the state of Tennessee instead of going to New York. And that's it.
Thank you, Mr. Chairman. We're going to go out of session unless anybody has a direct question for the chairman yet. If not, we're out of session. I take it you're Mr. Andrew Winnett and traveled a few miles to be here. Yes, sir. If you would, just tell us your name and who you're with. And you got 3 minutes.
Okay. Thank you, Mr. Chairman. Thank you to the members. My name is Andrew Winnett. I own a nationwide retirement planning firm. We're headquartered out of Nashville. We do a lot of different things at our company. One of the things we specialize in is the insurance side of retirement planning. Now, I will benefit more if this bill does not pass because we focus on the different investment vehicles that are protected from this UCC Article 8. However, I have a moral obligation to the residents of Tennessee and really the residents of the United States, because this is a problem in all 50 states, to be here and to stand up on behalf of Americans. Right now, every IRA, every brokerage account, every 401k is completely vulnerable of being taken in the event of a widespread custodial collapse. In September of 2008, Lehman Brothers failed. 2 weeks later, in October of 2008, we came up with the TARP program. We printed $700 billion approximately, which at the time was scandalous. That was so much money. And we infused capital into the very rascal banks that got us into that mess to begin with. We had money and room on the credit card to do so. We were only at about 10 trillion in government debt at the time. It's been said that if you fast forward 5 years from today, 50 cents of every dollar that we bring in tax revenue will go just to the interest expense alone on our debt. And within 10 years, 100 cents of every dollar that we bring in tax revenue is just going to go to the interest expense alone on our debt. We don't have any room on the credit card anymore to just print our way out of another mess. When the next recession and depression happens, and it will, it is coming, What's going to happen to the Tennessee residents? What's going to happen to the United States citizens? My challenge to you is this. Will you vote in the best interests of the people who elected you? Or will you vote in the best interest of the bank lobby? I hope that you will vote in the best interest of the people who elected you. And I'll leave you with this. Most arguments given by lobbyists are red herrings meant to confuse you so you get off topic. Simply look at what the Uniform Commercial Code in Article 8 says. It says it will protect the banks in a widespread collapse, and the investor is last in line. Thank you.
Thank you, Mr. Winnett. Any questions for our speaker? Speaker Marsh.
Thank you, Mr. Chairman. Thanks for coming today. And my question is, if we do pass this, what's going to change with the investment community? Are they not wanting our stocks to be invested with them? Are they not going to want them as much as they do now?
Mr. Winnett. Thank you, Chairman. It's a great question. Nothing is going to change. They may act like it's going to change, that it's, fundamentally going to change the entire system. Nothing changes except for the fact that if we had a widespread custodial collapse, I'm first in line to get paid back. You're first in line to get paid back. Tennessee residents are first in line to get paid back. It doesn't change any of the back end plumbing to how we operate our financial system. Zero.
Speaker.
And if we do have a catastrophic event, that more than likely a lot of this stock's not going to be worth anything either. So we're all going to lose.
Well, sorry. Great question. Thank you. Even in the Great Depression, people, if they didn't sell, would have still had their assets. It may have been devalued. It may have gone down by 50, 60, 70%, but it ultimately came back. We're not talking about losing 50% and having to wait a little longer for the value to return. We're talking about it being taken from you. And that is unacceptable. It's un-American. It's unconstitutional.
Any more questions? Mr. Winnett, thank you for being here.
Thank you.
Appreciate your testimony.
Thank you.
We have two other witnesses here, Miss Amy and Miss Stacy, if y'all would come forward. And please give us your names and who you're with. Y'all will have 3 minutes apiece.
Mr. Chairman, members of the committee, I'm Amy Hazlett with the Tennessee Bankers Association. Proponents of the legislation to amend Article 8, which you just heard, have said that its provisions allow a securities intermediary like a bank or brokerage firm to assume ownership of its customers' investment property like stocks or bonds in the event of the intermediary's insolvency. We simply believe this is false. Most investors today own their securities through a securities account maintained with a securities intermediary rather than holding the securities directly. This indirect holding system provides many advantages for investors, such as quick computer-based trading and secure backup of their account holdings. Under Article 8, an investor who owns securities through an intermediary has a property interest in the securities. Because the securities are not property of the intermediary, they are generally not subject to the claims of the intermediary's creditors. That is, the investors will not lose their assets just because the intermediary becomes insolvent. The proponents are focused on two narrow exceptions that apply only in special situations. They misunderstand the purpose and effect of those exceptions. So for exception 1, this applies when an investor voluntarily consents in writing to the intermediary pledging the investor's securities. This exception is known as a brokerage margin account and allows the investor to obtain a margin loan. It's similar to a consumer getting a $3,000 loan from a bank and needing to pledge something for collateral, like a $5,000 CD on deposit at the bank. As you all know, without collateral, loans are typically not made. For margin loans, investors are able to pledge their securities as collateral for the loan. If this legislation passes, investors could no longer pledge their own securities and margin loans would not be available for Tennesseans. Alternatively, if you don't want to go through that process, you don't have to obtain a margin loan and use your securities as collateral. In exception 2, this deals with secured creditors of clearing corporations. So clearing corporations are companies that play a central role in the clearing and settlement of most of the security trades executed daily by investors who hold their securities through brokers and banks. Article 8 gives priority to those lenders who extend secured credit to the clearing corporation to provide the liquidity that might be needed to settle trades at the end of each day if one of the intermediaries fails to perform its obligations to deliver securities sold or make payment for securities purchased. This extension of credit prevents one firm's failure from causing a massive market disruption that would harm all investors. So to put it simply, the ability to trade electronically is only available to investors because of the role of clearing corporations. If this legislation is enacted, clearing corporations may no longer be able to offer their services to securities traded electronically in Tennessee. I will add that this legislation has been presented in multiple other states as well and has been opposed by bankers and other groups in those states as well and has not been passed by any legislature. We urge you not to let Tennessee be the first state to make that mistake and pass this legislation. For that reason, I ask you to oppose this bill.
Thank you, Miss Amy.
I'll waive.
All right, any discussion for our guest? Chairman Vaughn.
And I don't know whether y'all are the best person to ask or the bill sponsor on this. It seems as if that we can't pass legislation that contradicts existing contracts. I assume, and correct me if I'm wrong, that whenever I punch all those I acknowledge, I assume, I take all that stuff whenever I'm forming my accounts, that I'm agreeing that I've got a contractual obligation that has certain terms and conditions to it that would bind this investment. So my question is, would this have anything to do with the accounts that are presently existing due to the existence of whatever contract between the investor and either the clearinghouse or the intermediary, or however you want to refer to it? That's my question on this is, even if we pass this, wouldn't it be a prospective going forward as opposed to affecting like the 56 billion that the TCRS has in it?
Miss Amy.
Or that might be better a question to ask for legal. That's.
Levin Crutchfield, Office of Legal Services. The Chairman, you're correct that under Article 1, Section 20 of our state constitution, as well as a federal constitutional provision, the state is prohibited from impairing the obligations of existing contracts. The legislation also has a specific effective date. And from my understanding, courts generally are not going to interpret statutes as applying retroactively unless there's some express intent to do so. So from my understanding, this would apply going forward and would not be able to impair existing contracts.
Chairman Vaughn.
So that would effectively mean that the assets that our bill sponsor is concerned about protecting would not be protected. It would be future investors that would be protected by this if this bill came to pass.
That would be my understanding. There are times as well where if a contract is renewed or amended after the effective date, that requirements that have been passed will kick in. But yes, it wouldn't kick in for things that are already in existence, already in contract, things of that nature.
Thank you, Mr. Chairman. Could I have one more question of the witness?
Yes, sir.
Because your microphone was off there towards the end because you grossly exceeded your 3 minutes. Did I hear you say that we would be the first state in the union to pass this bill?
Yes,
Ms. Amy.
that's correct.
All right. Thank you, ma'am.
Any more questions for our guest? Representative Hemmer.
Just a question for clarification. So practicality, if this were to pass, there was an issue, at least my understanding, that this would create an issue around jurisdiction. So you could have an issue where, Tennessee says, jurisdiction is Tennessee XYZ, and then Delaware would have the exact opposite from a UCC. And can you talk to me through the practicality of what problems that would cause?
Ms. Amy?
Yes, and I think there's a lot of testimony last year about that as well from some experts, but changing the choice of law provisions would put Tennessee as an outlier among all of the other states for where any lawsuits or legal actions would occur. It would disrupt kind of the uniformity where everything is settled in one state now. I can speak kind of to our experience, as general counsel for the Tennessee Bankers Association. Every time we enter a contract, we want choice of law here in Tennessee on our home turf. This is an exception where you want uniformity in the marketplace and consistency.
Any more questions? Ladies, thank y'all for being here. Appreciate your testimony. We'll go back into session.
Can I make a couple of closing remarks? Please?
Chairman, this is your world. We're just living in it.
The only contract that I know about is between you and your broker that you have, and that's who you would sue. You can't sue an intermediary. And the way the law is written, it states that they have priority to hold this. They got priority to your property based on the way the code is written. But the contractual thing that you have is with your broker only. He doesn't have your property anymore. And that's what happened in Lehman Brothers, is the suit over how this is written. And the only way you can fix it is to change who has priority in the meltdown. I had some other things I was going to tell you, but I got another bill coming up here, and so I'm done.
Thank you, Chairman. Any discussion with the sponsor on the bill? Well, I think we're ready to vote. Madam Clerk, will you open up the voting? All those in favor, vote aye on House Bill 2611. All opposed, vote no. Madam Clerk, please take the vote.
Mr. Chairman, you have 2 ayes and 5 noes.
House Bill 2611 fails to go to commerce on account of votes.
Thank you, Committee and Chairman.
Yes, sir. We're ready for agenda number 5 here, House Bill 2039. Need a motion and a second.
Second, just out of my love for this.
Thank you, sir.
I don't love the bill, but I love this.
You're scaring me. I have an amendment on this.
Yes, sir. Yes, sir.
It's 14254.
All those in favor of adding amendment to the bill, say aye. Chairman, it's all yours. Tell us about your bill.
Thank you, sir. This deals with programmable money. We passed a bill 2 years ago that said you can't be debanked and punished by your banking institution because of what you believe or your ideology or what church you go to or how you view things. And now we're coming across programmable money like CBDCs and cryptocurrency and stable coins that just came out with the framework out of Washington in June. They passed a law called the Genius Act to set the foundations for stable coins. And this bill just does what that debanking bill did 2 years ago. It says that because it's programmable, you can't use this system of money to punish somebody or treat them differently because of their ideology, belief, or what they believe, or who they associate with, or where they go to church. And it follows the very same kind of things we did before. It protects Tennesseans to engage in lawful transactions without being forced to use a program of money. Nobody can make you use it or force you to pay with it. It ensures payment choice and transparency and non-discrimination. The things prohibited, it prohibits any kind of coercion, and it prohibits decurrencing for ideological reasons. I can't even talk. I'm sorry. I'm dyslexic a little. I joined a new organization called DAM, D-A-M. It's Mothers Against Dyslexia. So you'll have to forgive me on that. Some of the things that this prevents is political opinions or affiliations, religious beliefs, race, sex, sexual orientation or gender identity, medical history, medical choices, lawful business activity or occupation, geographic location, lawful purchasing behavior, participation in constitutionally protected activities. So it keeps cryptocurrency money forms from beating you over the head and denying purchases or what you can or cannot do or spend your money based on your ideological preferences. That's all it does. It's a consumer protection bill. And I know that I got somebody here to speak on this bill, but I just want to tell you, this lady that's going to talk is an incredible woman. She is the most astute, capable, financial person that I have ever met in my entire life. And it's just it's a privilege that she's even here this morning.
So we're excited to hear from her.
She's a great lady.
We'll go out of session here with Miss Catherine and Toby. Please come forward. And if y'all would, just state your name and who you're with, and you'll each have 3 minutes.
So thank you. My name is Catherine Austin Fitz. I live in Hickory Valley, Tennessee, in Hardeman County, and I'm the former Assistant Secretary of Housing in the first Bush administration and a former partner and member of the board of Dillon Reed. I published something called the Solari Report, and we are focused on financial freedom, and I appreciate you and what Tennessee has done to do that. The central bankers, and I'll quote the central banks of central banks, the head of the BIS in 2020 said, the great thing about this technology is we can make the rules centrally and we have the technology to enforce it. If you track what they've been working on to implement CBDCs or doing CBDCs through private stablecoins and crypto, they have been very clear about their ability to set and control rules centrally through how they control our money, including where we can use it, how we can use it, and whether they can turn it or not if we misbehave. One of the goals of this bill is to make sure we don't all wake up and find ourselves feeling like Canadian truckers. It's that simple. My concern is that this will be the primary vehicle that will be used to implement this kind of financial control. One of the reasons that that some people here would argue we shouldn't implement or pass this bill now is because we are still waiting to see the regulations on the Genius Act, which Representative Halsey mentioned, which is the bill passed last year to create a regulatory framework for stablecoins. And we are still waiting for the Clarity Act to pass, which will hopefully create a regulatory framework for digital assets, digital tokens. The reason we can't wait for those regulations, what we need to put up the guardrails now is the market is not waiting. The issuance of stable coins is exploding and the issue of digital assets is exploding. NASDAQ has just made a deal and implemented settlement through the Fed wires to do this. And if you look at the outstanding, it's growing rapidly. I just testified in Utah. Utah has passed a very similar bill to this. And what they did is they delayed implementation so that if the bankers needed any changes, because we want to make sure that this is great for the banks of Tennessee, if any changes were needed, that gave them the time to amend the bill. But they said, we need to put up the guardrails now because the market is not waiting. The market's not waiting for the Clarity Act, and the market's not waiting for the bill. An example is last fall, Circle, the second largest issue of stable coins, put into their terms and conditions that you couldn't buy any weapons, you couldn't buy a firearm, you couldn't buy ammunition, and you couldn't buy knives with Circle stable coins. There was a huge hullabaloo. It was discovered, and they had to walk it back. But there is no laws now in place, no guardrails to prevent that happening in the private market now. We just ask that you pass this bill to do so.
Thank you, Ms. Catherine. Toby.
Thank you, Mr. Chairman, and I'll try to stay way under the 3 minutes. There's not a whole lot that I need to add anyways. Just that much. We take it for granted that we go to a store, to a gas station, to a restaurant, we need to pay for something, and we're able to do so somehow. What this prevents is us all of a sudden finding us in a situation where we're not able to pay anymore because somebody does not like what we did or what we believe or what we said. That is what this does. It does not prevent anybody from launching a new financial product that they deem a good idea. It does not stop innovation. You can launch whatever you want. It just prevents two things. One, you cannot be forced into a system that is basically the lineup to a social credit score system. You cannot be forced to pay with this one particular form of programmable money, which can literally work differently for whoever owns it. It does not work the same for every person anymore. The other thing that it does is, like Chairman Halsey said, it basically mirrors what Tennessee has already passed for or against debanking. It does the same against decurrencying. It's bad enough if you lose your bank account. If you lose your currency, your ability to pay, you are a non-person. And this is what this prevents. And Utah, like Ms. Fitz already said, has already passed this, so we wouldn't even be the first state to do this.
Thank you for your testimony. Any questions for our guests? Representative Lynn.
Thank you, Mr. Chairman. Ms. Fitz, I have to say, when you came up here, I was really surprised because I've seen you before many times on different, programs, podcasts. So the fact that you're here, it means a lot. So thank you.
Any more discussion? We thank you for your time and being here. Yep. I think we have Miss Stacy and Amy again, if y'all will come forward. And Todd? Yes. If you would, just state your name, who you're with, and each of you all will have 3 minutes.
Thank you, Mr. Chairman. If you don't
Ladies
mind.
first.
Okay. Thank you, Mr. Chairman, members of the committee. For the record, my name is Stacy Langford on behalf of Tennessee Bankers Association. On behalf of the Tennessee banking industry, we appreciate what the sponsor is trying to do here, but we believe that House Bill 2039 is not the right step to take at this time and could unintentionally inhibit responsible innovation around stablecoin and some of these programmable payment technologies. So stablecoins and programmable payment technologies are a rapidly developing part of the broader financial ecosystem. And as was mentioned, just this past summer, Congress enabled the establishment of a regulatory framework for payment stablecoins through the Genius Act, which was spearheaded by Senator Hagerty. This is still actively in the rulemaking phase at the Department of Treasury, and it will provide standards for stablecoin issuance, consumer protection, reserves, and regulatory oversight. It also preserves a role for state regulators within that federal framework. So Tennessee's community banks are currently carefully and actively evaluating how these tools can improve payment speed, reduce settlement costs, strengthen fraud controls, and provide Tennessee businesses and customers with improved liquidity and faster, efficient ways to move money. We're working to understand the role that the traditional community bank has within this new payment ecosystem, and we do not want to be left behind. House Bill 2039's broad prohibitions on how programmable money can be used and the restrictions we feel are premature and could interject risk into the system and create an environment of legal uncertainty in Tennessee around these payment innovations. We fear that would discourage local banks from participating in this innovation and ultimately diminish their competitiveness. And for these reasons, we would respectfully ask for your opposition at this time. And though well-intended, we believe that it is not the time to enact these constraints as a state, and it may inadvertently inhibit innovation that could be a benefit to Tennessee consumers and businesses. That's all I have.
Thank you, Ms. Langford. Mr. Toby?
Yep.
I'm sorry, Mr. Todd.
Yeah, no problem. Todd Staley, Department of Financial Institutions. I don't want to be too repetitive here, but the department is not aware that, banks are widely engaged at all in stablecoin yet for our Tennessee banks. But the bill itself may hamper our Tennessee banks from the ability to innovate. As previously mentioned several times, we have the Federal Genius Act that was enacted last year. A lot of these rules and regulations are still in the pipeline and being developed. So we certainly don't want to do anything that's going to put our Tennessee banks at a disadvantage. The legislation itself would not apply to national banks or out-of-state banks, and so that kind of puts it on a different tier with our Tennessee banks. Because we are getting into this realm of stablecoin, we don't want to put our banks at any type of disadvantage of trying to take the challenges and opportunities that come along with the Genius Act. I'll wrap up by saying that the Genius Act provides a pathway for states to develop their own regulatory program. And while we've not done that here in Tennessee, we may. And those programs have to be substantially similar to the federal standards. And so we may be, getting out of sync with that and could be problematic in the future. So thank you.
Thank you, Mr. Thank you, Mr. Staley. Any questions for our guest? Representative Hemmer.
Thank you, Mr. Chairman. Question for you, Todd. I think I emailed you over the weekend trying to make sense of this, as I'm not an expert on. I can't tell you the difference between a stable coin, a Bitcoin, or a regular coin. But the one thing you had was talk about the state level regulatory programs that were or through the Genius Act that we'll be able to do within Tennessee once those rules are established. So is there a potential for once those rules are established to do something like this bill is talking about from a rule-making perspective?
Mr. Staley.
Thank you, Mr. Chairman. Thank you, Representative Hemmer. Thank you, Representative Hemmer, for that question. So we don't know yet exactly how the federal rules and regulations will pan out. So if something like that's included, then it would be something we could look at, but we have to, again, the state program has to be substantially similar. In essence, the federal government has to sign off on the state level programs. So we would want to make sure that we're trying to be consistent with that. So again, we would have to wait and see if the particular provisions of this bill were something or similarly included in what the federal government is doing on their end.
Representative Hemmer.
Oh, thank you, Mr. Chairman. One last follow-up question. You mentioned about the disadvantaged from our state charter banks versus the nationals because of that. Can you dive into that a little bit more? Why would this be a disadvantage?
Well, thank you, Mr. Chairman. Thank you, Representative Hemmer. We cannot, just through general preemption concept, we can't impose on a national bank or an out-of-state chartered bank the provisions of the bill. We don't regulate them. They're not under our regulatory jurisdiction. And so that creates a different playing field for those banks, national banks and out-of-state chartered banks that are operating in Tennessee versus our Tennessee chartered community banks.
Chairman Vaughn.
Thank you, Mr. Chairman, and for our witnesses here. Thanks for being here. I'm looking at what this bill has in it, and who can't be for prohibiting an issue of programmable money from denying a transaction on the basis of political opinions, free speech, affiliations, religious beliefs, gender, skin color, medical. That sounds like all the things that we want that truly address the values of our state and our communities. And so what I'm picking up on is that you're not in opposition to the content of the bill. It seems to me that because of the Genius Act, you have more of a concern with timing of the bill and when it's being brought forward. Is that a fair statement?
Yes, sir.
Thank you, Mr. Chairman. Thank you, Chairman Vaughn. I believe that's accurate, that we're kind of maybe getting the cart before the horse, but yes.
Thank you for confirming something I've always thought, I've suspected, and that is that the bill sponsor is a man that's ahead of his time. There's no doubt about that. All right, well, so and allow me to frame this in my head is that your testimony is to follow up on that. Is that by being early, we could inadvertently create a system that would have to be undone to conform with national standards, or it would have to be ignored. Is that a fair statement, or am I misinterpreting?
Thank you, Mr. Chairman. Chairman Vaughn, it's a lot of uncertainty around it. So, as we are still trying to determine what a state program even looks like and how other states are doing it and what the federal rules and regulations will be, we just don't know. So we would want to be cautious.
And thank you, Mr. Chairman. Thank you for the leniency. I've got one final point that I'd like to make, and that is for years, this body held up us adopting the Uniform Commercial Code because of concerns of us getting out in front of things. I think we went from being like in the first 10 states, we considered that to be too risky to adopt the Uniform Commercial Code revisions. until now we're going to be in more of the 40s with regards to our acceptance of it. And so I see this playing out again here in the fact that we're not being asked to be the first, but we're asked to be the second. And to me, that's given the fact of the lack of consistency between national banks and Tennessee chartered banks. Most consumers don't say, I'm going to this bank because it's a nationally chartered bank, or I'm going to this bank because it's a state, but they're going to have different rules with regard to that. They're going to be treated differently. And so that's a concern to me that it seems like if this new frontier that I feel like Phil Hartman's caveman on Saturday Night Live, there's these new things that I don't understand, that I'm concerned about the race to be early in this case. And that's just one person's opinion on this matter. But thank you for my indulgence, and I thank the witnesses for helping me think through that. But again, a man ahead of his time.
Thank you, Chairman Vaughn. Representative Lynn.
Thank you, Mr. Chairman. Mr. Chairman, your comments really made me think, Utah is number one, been rated number one for economic competitiveness. A book by Dr. Laffer and Alec, Rich States, Poor States. And there's some other co-authors with that, but they've been rated number one for economic competitiveness, and they passed a similar bill. Tennessee last year, for the first time, came in number 2. I think previously we were about number 13. And that's quite an honor, and it's really amazing. So given that Utah they're really considered high profile when it comes to their government and what they do, and so is Tennessee. Tennessee is looked at as a leader in this country, and people look at us and say, wow, how do you do it? How do you do what you do in Tennessee? And it's really because of, this body, people in this room, and our gubernatorial leadership. But I'm wondering if we did pass this, would we be showing some leadership as for our expectations for the federal rules? Because as you read that list, you just say to yourself, who wouldn't respect those items? Who wouldn't want those items included? So I'm just thinking out loud and pondering this, and I agree with you. Representative Halsey has always been a visionary. He is a man way ahead of his time, and he's a treasure. So I'm still pondering it, but I'm interested in hearing other comments, so thank you.
Thank you, Representative Lynn, for your comments there. Any more? Speaker Marsh?
Thank you, Mr. Chairman. I'd like to, this is all new to me. I think we're in a new world talking about this. What, in your all's opinion, or what is programmable money, and what is a stable coin, and who issues it, and who backs it? And just give me a little history on what we're trying to do here. This is also new. I want to regulate it, but I want to regulate it properly.
Do you want to take that?
Thank you, Mr. Chairman. Speaker Morris, I will try to give a high-level overview. So, we speak in general terms of digital assets, and a type of digital asset includes virtual currency such as a cryptocurrency or Bitcoin. But then also within this classification, you have stable coin. The difference between, say, a cryptocurrency and a stable coin is the cryptocurrency value is determined by the blockchain and its trading and the market, if you will. Stable coin is tied to a fiat currency, such as the U.S. dollar. I believe that's why Congress started with regulating stable coin, because it's closer to fiat currency is what we're used to dealing with. And so that's kind of been the starting point with it. And it's probably where more institutions will be delving into, like kind of dipping your toe in the water, because there's not as the same associated level of risk that you have with, say, cryptocurrency. It's all in the name stablecoin. So I hope that started an explanation.
Well, is it issued by the federal government or is it issued by?
No. So the stable coin, thank you, Mr. Chairman, sorry. The stable coin is issued by a third party. So there's a number of them out there, but they are tied to some fiat currency, the US dollar, the euro, it's something out there. So that can be more attractive to consumers because there's a little bit more stability than, say, with a regular cryptocurrency. Cryptocurrency is attracted to other consumers because of the volatility. They like up and down. And so it's something similar to that. Yeah.
Thank you.
Good back and forth. Any more questions? Appreciate y'all being here. Appreciate your time. We'll go back into session.
Thank you. Just a couple of closing remarks. I appreciate your time, and I'm done. Listen, you don't build a house till you put the foundation down. The foundation's important. This bill just deals with two things. You can't force somebody to join this program and spend money called cryptocurrency if you don't want in it. If you do want in it, you can't be persecuted because of what you believe. Now, it doesn't matter how much framework goes into a stable coin from the federal government. The federal government is not going, and neither is Senator Haggerty, going to say, well, let's tolerate some discrimination out here for the first 2 years till we get the platform under us. They're not going to say that. These are fundamental things that we should all stand together on, regardless of who puts out stable coin or any other coin. It's fundamental that people should not be punished because of what they believe. And that's all this bill deals with. And I would say this. These banker folks are nice people. They've always been kind to me. But they are not tasked with the responsibility of preserving the sovereignty and the liberty and the financial security and independence of Tennessee people. They work for a bank. You and I, on the other hand, are taxed with that responsibility of preserving Tennessee's people's liberty, sovereignty, and financial independence. I'm just asking you, don't fail them. Don't fail them.
Thank you, Mr. Chairman. Any discussion with the chairman on the bill? I think we're ready to vote. Madam Clerk, please open up the vote. All those in favor of House Bill 2039 moving forward, vote aye. All opposed, vote no. Madam Clerk, please take the vote.
Mr. Chairman, you have 2 ayes, 4 nays, and 1 present not voting.
House Bill 2039 fails to go on to commerce.
Thank you, Chairman and Committee.
Yes, sir. We're going to skip around here just for a second here. We're going to skip to item number 9. Yeah, I told you. Chairman Williams, please come forward there.
I was so enamored, Chairman, by Bud Halsey's performance, I didn't really want to follow it. But to be honest with you,
yes, sir.
Chairman, members, I do have an amendment which.
Chairman, hang on just a second. We got a motion in a second. And you got 2 amendments, is that right?
I have a plethora of amendments, Chairman, but the only one I'm really interested in talking about today is 014963.
014963. All in favor of adding that amendment to the bill, please say aye. Sir, you're in proper motion.
Thank you, Chairman and members. This bill is entirely new to me, and I do feel a little unusual following Chairman Halsey when it has to do with gold. I know he's been here in your committee for many years as it relates to gold. But this bill that's before you as amended, it just creates a mechanism that allows citizens at all income levels to hedge against inflation by being able to buy transactional gold and silver while making those assets usable in everyday transactions utilizing a debit card. The reason why it's really important to me is, as many of us, we grew up in the idea as children and young adults working in the community, the idea of buying gold was for wealthy people and storing it in a safe somewhere. This just allows every individual citizen in the state to be able to buy a small portion of gold, which is held in a repository based upon whatever they can pay at the time. They actually own that gold, and that their ownership of that gold allows them to be able to use it transactionally in the future, just like they would their regular check card, except it's instead of being backed by a U.S. dollar, it's backed by the gold in which they purchased in that repository. This bill affirms gold and silver as legal tender, which has been before this committee before, and creates a voluntary opt-in legal framework for state-authorized private bullion depositories and payment processors. It removes taxation on the exchange of one form of legal tender for another. It allows private providers, those bullion depositories, to compete in an open marketplace under industry best practices and basic consumer protection standards under a state promulgated rules and regulations oversight. Its participation is entirely optional to folks, citizens, businesses, and institutions. It does not replace the dollar. It simply allows lawful alternatives to the function of a dollar. As I said earlier, it just allows you to purchase gold and have it on check card. And if you wanted to buy just a little bit of a gold a week as a part of your electronic transfer, you could do that. And then over time, you have this asset that has grown in asset value over time. Or much like your investments, if you were to put them in a 401k, you have to pay a huge penalty in order to take that money out and use it. This is something that I think would be good for other states have done it. 5 other states have done it. I think it's a good opportunity for us to make this opportunity available. I want to thank the Treasurer's Office for working with me and my constituent as it relates to this issue. That's why there are so many different iterations of the bill, but the one before you, I've worked with them on. You can't make everybody happy, but I think we've made as many as happy as we can. With that, Chairman, members, I'm happy to answer any questions. I do think you have a lot of for and against.
Yes.
Yep.
Thank you, Mr. Chairman. We'll go out of session here. We got some people that were wanting to speak. Miss Laura Bolton and Mike Carter, will y'all come forward, please? If you would, just state your name and who you're with, and you'll both have 3 minutes.
Mr. Chairman and committee members, my name is Laurie Bolton. I've been a resident of Tennessee for 20 years. I want to point out that I'm not a lobbyist. I'm a constituent, and I really care about this. No one's paying me to do it. First of all, Senator Nicely was a good friend to my colleagues and I. He loved this bill. He loved this concept. I know he brought bills about gold before this and other committees in the past. He took Treasurer Lillard and some others down to the Texas Bullion Depository to visit it a couple of years ago, and he really believes in what we're doing. This bill's been passed in Texas, Florida, Arkansas, Louisiana, and Missouri, and they're in the implementation phase. Several other states are moving forward this session. Tennessee, as was mentioned earlier, has long been a leader in fiscal responsibility and financial freedom, something Senator Nicely cared deeply about. The bill simply does this. Money should hold its value over time, but it hasn't done that. Because of federal overspending and money printing, now with over $38 trillion in national debt, the dollar has lost about 90% of its purchasing power since 1971 when we left the gold standard. Our bill does recognize gold and silver as legal tender, but makes them functional currency, easy to buy, save, and spend when needed. Inflation is quietly eroding the purchasing power and wages and savings of the middle class and working poor. Wealthy investors can hedge with assets, but most regular people cannot. This bill gives the average Tennessean access to gold and silver as a hedge while allowing it to be used easily through a debit card system. You will see in the comparison that I left each of you that our bill is very similar to HB 2038, the Frank Nicely Act. Both declare gold and silver legal tender, both allow physical gold transactions, but neither forces anyone to use it. HB 24/7 goes a step further. It allows it to be stored in a state-authorized depository or depositories. They're privately run, not owned by the state, not operated by the state, and linked to a debit card. They would go through the same RFP process, just like the payment processors would do. But what it does is it allows people to buy gold, $5, $50, $5 million, however much they want, store it securely, and spend it when needed. When it's used, the gold converts instantly to dollars at market price, making it frictionless for both the buyer and the seller. So if I use my card at Walmart, it gets turned to dollars and the vendor receives dollars. Right now, gold is technically legal to use, but it's impractical. An ounce gold coin is around $5,300. I can't afford that. And I wouldn't be able to use it. I wouldn't be able to spend it easily. This system solves that problem. The bill does not interfere with gold or vaulting industries. They can continue operating just like they do now. But if they want to operate in the legal tender money space, they have to follow the state guidelines. I am a small government conservative, but the state has a limited but legitimate role in having some regulation over monetary matters. The Department of Financial Institutions will set forth consumer protection guardrails, and the state will authorize private depositories and payment processors.
Thank you, Ms. Laura. That's all right. Yes, sir. Mr. Carter?
Yes, thank you, members of the committee and chairman. I'm testifying in support of House Bill 2427 as well. We've heard about geopolitics today. We heard about record debt. We heard about programmable money, all things that are potential threats to our economic freedom. This is a reasonable, easy to move forward solution that kind of goes back to the future. Article 1, Section 10 says states can have their own legal tender as long as it's backed by gold and silver. It's not been practical today that it is. This is legislation. The framework was built upon by ALEC. We had 500-600 legislators meet in Indiana this last summer and say, yeah, this makes sense. This is fiscally responsible. It makes sense to give people another way to pay. This is legislation that 5 states have passed now that make gold and silver legal tender, make it easy to spend with a debit card. We've seen it move forward in Texas, Florida, Arkansas, Louisiana, Missouri. Just passed in the Senate on the floor vote in Georgia, just passed on the floor vote in Utah on both the House and Senate. Other states are moving forward with it as well. But it is a practical solution, and we've seen bipartisan support. Democrats and Republicans saying, hey, this makes sense because it's economic justice. Key benefits for Tennesseans: voluntary legal tender for debts, and if accepted, maybe for taxes, but it's done on a debit card. You don't have to take gold or silver. It's done electronically. It's a real choice beyond fiat. It's a built-in inflation hedge with intrinsic value. The money printing continues out there. We've got the record debt. We've got more and more money printing taking place, which means the money we have saved is worth less. So central banks, what are they doing? They're all holding gold as part of their rainy day fund. We want Tennesseans to have that same opportunity, to have their own rainy day fund out there. This removes tax exemptions at the state level, removes other barriers, boosts liquidity, boosts the ability to be able to spend this easily. It builds resilience. It attracts stability-focused savers and businesses out there. It's fully opt-in. It's not mandatory. There's safeguards that ensure transparency and fraud protection. And the last minute, I'm just going to go through. I know there's some opposition to this. Some of that is probably based on lack of understanding of it. Some of it may be purposeful. Some of you might have seen letters out there. This is a government boondoggle. Far from that. This is optional, setting up safety rails that protects the consumer to make sure that the gold they buy is real, the purity is there, and it's secured in a stable store environment. I was in Georgia the other day and actually heard people calling and saying, well, the government's going to take my gold ring. That's not what this bill does. That's misinformation out there. And in fact, I was looking at the one that was putting that out there and seeing that they've got 50% one-star reviews out there with things like half report delays, short orders, loan and bait and switch, hidden fees, poor service, depository issues, low appraisals, and surprise costs. That's why we need some safety and guardrails to make sure this happens. That's a vendor called Money Metals. Look it up. That's at trustpilot.com. The other opposition is as it relates to this should be private only. If you want this to be money, it can't be private only. It has to be actual. As a retailer, I need to know that if you're spending gold through the system, the gold is real.
Thank you, Mr. Carter. Yes. Any questions here? Speaker Marsh.
Thank you, Mr. Chairman. And let me ask you this. You said it's legal and Missouri passed it.
Yeah, 5 states have passed framework legislation that allow the transfer of gold to happen. So Texas, Florida, and Arkansas probably have the models closest to where you're at right now. Missouri's passed this as well as Louisiana, and they're opting and tweaking it as they go forward now.
So if a person that's in this program in Texas comes to Tennessee, can they use their debit card here in Tennessee and purchase supplies?
Yes. I will say there's conversations amongst treasurers now to make sure that there's interoperability between states. So it's consistent, much like a toe tag works out there now. But the technology exists today. I have an app on my phone I can buy gold right now at spot price at the instant time. I can spend gold at the time, but it's converting it to fiat. What this does is recognizes gold and silver as legal tender, as our founders envisioned. And it'll also allows retailers, if they wanted to, once you make this legal tender and move this forward, if they wanted to be paid in gold instead of the fiat currency, they could do that as well. That's a natural optional way to pay out there. And I share that just, my reason for being passionate about this. I had a guy from Zimbabwe come to me and says, you've got to get this passed. It was in Texas. And he gave me a $50 trillion Zimbabwe bill that was worth nothing. He said, I had to trade my truck in for 3 loaves of bread. If I could have had one of these cards, I could have gone to the grocery store and paid everyday low prices to buy food. Please get this done. That's what we're asking for Tennesseans. Let's do a reasonable way, a practical solution that lets the free market compete, sets up safety rails, and sets up another way to pay as our founders envisioned.
Speaker.
Wouldn't it be more practical to do this federally instead of by each state? I mean, I think I understand what you're saying, but it looks like every state's going to have different rules and regulations and guardrails, and you want this to be able to work all across the nation, all across the world, I guess.
Yes. Well, the Constitution gives the states the right to do this. So constitutionally, states have the right to make gold and silver legal tender. It's a state solution. Unfortunately, getting back to the gold reserve is not an easy solution on our national basis, given the debt we have out there. But states can do it, and individuals can do it. You're given the rights to do that. This runs on the rails of the money transmitter systems that are out there today. So MasterCard and so forth, anti-money laundering, all the systems that are out there that's running on those systems. But the states need to enact and say, yeah, we recognize this as legal tender, and there's other benefits to the states that do that as well.
Thank you.
Any more discussion? Thank you for being here.
Thank you, everybody.
Would Mr. J.P. Cortez and Kim Coleman please come up? If you would, just tell us your name and who you're with, and you'll each have 3 minutes.
Am I on? Am I good?
Yes, sir.
Hi there, committee, chair, and the rest of the committee. Thank you very much for the opportunity to testify before you today. My name is JP Cortez. I'm the executive director of the Sound Money Defense League, and I'm here in strong opposition of House Bill 2427. While we appreciate the apparent desire of elected Tennessee leaders to implement what they may believe are pro-gold and silver policy generally, this is an ill-conceived measure that births new government programs that would lead to harmful interventions in the gold industry, unfairly pick winners and losers to the detriment of Tennessee businesses, and create a boondoggle for Tennessee and its citizens. This bill would damage free market competition, and it's a step in the wrong direction. Legislators in other states have recognized these vendor proposals for what they are and rejected them in Kansas, Michigan, Wyoming, New Jersey, Oklahoma, Iowa, West Virginia, and Idaho. And just in the last month, Mississippi, South Dakota, Kansas, Indiana, and just yesterday, Arizona voted to kill this bill as well. This bill envisions a private-public partnership between the state of Tennessee and a small handful of gold vendors who would jointly roll out services that are already completely and freely legal and available for use here in Tennessee today. This bill does not increase choice or do anything to make gold transactional. One can already do that legally right now in the private sector. This bill, in effect, the legislation would have the state of Tennessee become a precious metals dealer or a depository, or blessing a depository that's already existing and competing, while creating, launching, and managing an electronic payment system and asset custody scheme that intertwines itself with both the private personal finances of Tennesseans and the state government. In general, there's virtually no public demand to spend or pay taxes in gold. This is explained by economic law. This is what Gresham's law says. No one wants to spend their gold so long as vendors and taxing authorities are willing to accept Federal Reserve notes. On top of that, every time you quote unquote spend your gold, you're triggering a federal tax. This is a taxable event every single time you swipe this card. So there is no reason. This is why people don't do it. Notably, Catherine Austin Fitts and the Solari Report, who were here earlier, are against this bill in Tennessee and in other states where this has been introduced. Firms offering gold and silver for purchase, storage, or payment should compete in the private market. The government shouldn't be picking winners and losers or handing out special government designations to businesses that are already legal and competing here. This path could also lead to litigation. The Texas comptroller, we've heard about how Texas has already done this. The Texas comptroller was sued last month by private businesses alleging that the state's offer to offer precious metals products against competing businesses that already exist in the state they were sued for this act. And all the meanwhile, Bank Secrecy Act, these firms are already subject to the Bank Secrecy Act, to federal anti-money laundering, and a multitude of criminal and civil laws. The solution to this problem isn't staging a partial government takeover of the gold industry. After all, it's big government problems that got us here. But this bill does far more than provide guide rails for private companies without government involvement. In reality, it directs the state treasurer to designate or establish a bullion depository, authorize or oversee an electronic payment system, contract with select private entities, and promulgate rules under the Uniform Administrative Procedures Act.
Thank you, Mr. Cortez. Yes, sir. Ms. Coleman.
Thank you, Mr. Chair. I'm Kim Coleman. I'm with a company called Goldback out of Utah. Our president and founder is actually a Tennessee resident. We are a fractional gold wholesale company, so we know all about getting smaller denominations of gold into regular people's hands so that they can use them. We appreciate the efforts to advance the idea of allowing gold and silver to be used as money again. We are true believers in this, and we agree with the motivating concerns about the past, present, and future of our monetary policy, especially how it has harmed the purchasing power of Tennesseans. We support Tennessee recognizing gold and silver's legal tender and related common sense tax exemptions, and we support state treasuries storing gold and silver reserves as a hedge against inflation. It is important to know that there are variations of these bills in states that very few look like this, and only 3 have passed. Most states have overwhelmingly rejected this idea. I need to disclaim that only minutes ago I was made aware of the amendment. I still have not seen it. And so I would like to speak to a little bit of the original intent and what we hope was removed from that bill. But we oppose the efforts of the state government getting into a financial services arena. Hundreds of private sector providers offer the secure depository services, and residents of Tennessee do not lack access to those services. Thousands of private sector companies buy, sell, and exchange gold and silver, and residents of Tennessee do not lack access to these services. And about a dozen companies provide precious metals-backed electronic payment systems, as has been discussed today with the debit card already happening, already completely lawful, already thriving in the private market. Current gold depository exchange services are FinCEN regulated, IRS, anti-money laundering, KYC, federal and state laws. As applicable, they're regulated by money transmitter laws, SEC, FTC, CFTC, AABC of the regulatory industry. And as with other businesses, they must comply with local business licensing and state consumer protections laws. Those are already in effect. In 23, Mercatus Center recognized Tennessee as the 24th in the nation for regulatory burdens. While this body is seeking to cut red tape, this bill may impose unnecessary, undemanded new regulations on the gold industry. The states with the best legal tender laws, I would shout out, Missouri looks nothing like this. It just simply recognizes its constitutional right to declare gold and silver legal tender. And that can happen without creating a new regulatory scheme that may overburden the industry. So we ask that I registered as being opposed to this bill. I just can't see the amendments. It is my hope that it does not seek to overregulate unnecessarily.
Thank you, Ms. Coleman. Any questions for our guests? Thank you all for being here. We'll go back into session. Chairman.
Thank you. I was just looking at Department of Financial Institutions. I don't know
if there are any questions, we've got him on standby.
Okay, perfect.
Yes.
Just to be, and I know the committee's up against time, but and I'm not trying to disparage our guests who came here a long way, but most of what they said has nothing to do with this bill as amended. So a lot of the issues as it relates to repository were because, and I'll be completely frank, I think the state should invest some of its little over $2 billion in gold and put it in a repository here to protect the investments of our state. I think we should. The original bill pontificated the idea of being able to do that. If I were in a gold repository business, I definitely wouldn't want the state to be in a gold repository business. But that's not what this bill does now as amended. I did, as she stated, I did have an opportunity to visit with her briefly outside. I hope that we can have a discussion after that. But simply what this is trying to do, and I'll speak on behalf of Mr. Staley's angst. He came to meet me before. The only regulatory part about this is that the treasurer and I, when we worked through the bill, we were trying to figure out who would be the best home as it relates to regulate this portion of the business in the state. The treasurer seems to think it would be financial institutions. Financial institutions seems to think, hell no. And so pardon my expression, but the goal would be to work with Todd and his team and the treasurer's team if this bill were to find some favor in this subcommittee today, so that we can move forward and continue the discussion, so that I can make it. He just, in his defense, he just found out about this a couple of days ago, and because of the mandatory process, and he did do a great job in coming to see me today, and so I want to thank him for that. So
yeah,
that's kind of where we are with the bill, Chairman.
Let me go out of session one more time and let Mr. Staley come up here and tell us what he knows. Out of session.
Thank you, Mr. Chairman, members. Once again, Todd Staley, Department of Financial Institutions. I don't want to correct the chairman, but I did not use those exact words, and I appreciate getting that clarified on the record. Thank you. So, yes, the original bill put this under the treasurer, and we respectfully disagree with the treasurer that the department is the best place to regulate the bullion depositories. The language in the amendment that you adopted simply states that the commissioner has the authority to regulate the bullion depositories, and we will do so by promulgating rules. There is nothing in the bill that speaks to the form of that regulation. There's no direction, the requirements, standards, fees, qualifications, all the things that we would typically see in a regulatory scheme is being left entirely to rulemaking. That's a very uncommon approach. From a philosophical standpoint, the department does not believe that we should start to regulate an entirely new entity type and do that unilaterally through rulemaking. We typically partner with the legislature in coming up with new regulatory programs. We simply do not have the expertise or staff at this time to take on this new mission. Moreover, I'll just point out, based on the amendatory language, this has effective date of July 1 of this year, so we certainly are not afforded sufficient time to hire, train, get the additional staff in place, and then also go through the rulemaking process, which I think you all are aware is not always the quickest way of getting regulation in. And so just wanted to raise those issues. We had a really good discussion with Chairman Williams. I appreciate him taking the time, and also been having discussions with the proponents of the bill. So just want to make sure we have that while we've got the time today. Thank you, Mr. Chairman.
Thank you, Mr. Staley. Any questions here? We'll go back into session. Any questions here for our sponsor? We're ready to vote. Madam Chair, please open up the voting. Madam, please take the vote.
Mr. Chairman, you have 7 ayes and 0 noes.
Thank you, Chairman. Members.
House Bill 2427 will move on to commerce. Thank you. Hey, real quick here. Have y'all got to go? We'll listen to one more real quick. Hey, no. Also, Chairman, we're now ready to hear House Bill 2254. May we have a motion and a second?
Motion.
Chairman Boso, please tell us about your bill.
Thank you, Chairman Darby. There is an amendment that I'd like to put on.
I'm sorry, there is. 14428.
Exactly.
All those in favor with the amendment, please state aye.
Aye.
Chairman, you're ready.
Thank you, Mr. Chairman. Good afternoon, members of the committee. This bill is, if enacted, is the App Store Accountability Act. It seeks to prevent digital exploitation of minors online. And it works in a couple of ways, but typically it works by putting requirements on developers and App Store providers of minor accounts to require that those accounts be affiliated or associated with the accounts of parents. I understand there have been some concerns that have been raised regarding digital privacy and burdens on interstate commerce. So respectfully, I'd like to request that the committee consider moving this to a true summer study so that the concerns that have been raised can be properly analyzed, support from interested parties can be submitted, and we can get this in a posture early next year that it could be passed.
Thank you, Chairman. Chairman Vaughn.
Thank you, sir. I believe everybody is interested in the protection of the innocence and the safety of our children, but I do agree with you. This is a complex issue that it needs to have the appropriate amount of time to make sure that the solution that's proposed is the right solution. And we've had conversations with a lot of the digital providers, and they have agreed that we will convene a summer study for this, and we'll make it legitimate and give it the thoughtful consideration that it deserves. And with that, Mr. Chairman, I move that we send this one to summer study.
Proper motion there. All in favor, say aye. Madam Chair, will you please open up the vote to send House Bill 2254 to a true summer study? Madam Clerk, please take the vote.
Mr. Chairman, you have 5 ayes and 0 noes.
House Bill 2254 will convene this summer.
Thank you, Mr. Chairman. Thank you, committee.
Sorry about the rest of the bills. We will catch you next week. All I need now is a motion to adjourn. So adjourn.